You're having a super fantastic sparkling day. Welcome to Before the Dirt Nap podcast number 1992. And tonight we are understanding eligibility in historical legal documents. Now, in the description below, there is a website that I'm putting there that's back up a little bit. Tonight's topic was inspired by an email I got. Hang on, where's my email? Which is a genealogy tip of the day. And they send out these tips of the day, and some of them are really cool and some are not. And some of them they're just basically really cool stuff. And it comes from genealogytipoftheday.com. And their one was who is eligible and who is forbidden when it came in relation to legal documents. And they had you go to Advancing Genealogist's website to be able to look up the different laws in different states. Now, this basically pertains to the United States for tonight's one. And so when you go, there's a website listed in the description below for advanced genealogists, and it takes you to the laws and statutes, and then you pick the state and you can read when different laws changed and different things like that. So if you want to dig deeper, that resource is there available for you. So let's dive into this. One of the ones was witnesses in wills, and if I know the British equivalent, I'll be able to tell you that as well. Witnesses in wills. Colonial America, 1600s to the 1700s. Witnesses were typically property-owning men. Property ownership indicated a stake in society and trustworthiness. For example, a will in the 1700s Virginia might list 3 male neighbors, all landowners, as witnesses. Women and enslaved people were excluded by law. So these changes have taken place to reflect the era's matriarchal and property-based social structure that was around at the time. In the late 19th century, witnesses expanded to include non-property owners and, in some case, women. Sorry, I just wondered what the noise was behind. She brought a treat in to have. For example, after the Married Women's Property Acts of 1848 to 1900s, in various states, married women gained more legal rights, and some states allowed them to witness wills. Showed a growing recognition of women's roles in legal matters. Now, one thing I will state about the wills is that, where was it? I've got to go over here for this one. Someone who witnesses a will must be from a disinterested party. This usually means that they were not an heir at law or of the sorry, I can't speak tonight. Heir at law of the testator or the beneficiary of the will the testator is signing. So if you were mentioned in the will, you could not be a witness to it, basically is what that was saying. And that's still pretty much the same today. I'm trying to remember if it is or not. I think it is. I was trying to remember when Brad and I got our wills done. I can't remember. The Homestead Act witnesses from... Take it easy there, little one. Chew it properly. Sounded like she was hacking there a little bit. Homestead Act witnesses from 1862 to 1976. The initial rules in the 1860s is witnesses could not be related to the claimant and had to confirm residency and land improvements. So, for example, a homestead claim in Kansas in 1875 required 2 unrelated neighbors to vouch for a farmer's land cultivation. So if the claimant was here in the middle and he had family surrounding him, he had to go beyond that to find somebody else in the community, 2 people in the community who were not related to him or to each other to come in and vouch for what he'd done in his land. And by the early 20th century, the government streamlined homestead processes, reflecting a more regulated and less community-based system. And this demonstrates how legal frameworks adapted as the frontier closed and oversight centralized. Guardianship laws. This is all pertaining to children. So in the early 1800s, guardians were often the nearest male relative, regardless of competence. Courts prioritized inheritance preservation over the child's welfare. So a child orphaned in 1825 might be placed under the care of an uncle to manage their estate, even if the uncle lacked caregiving skills. And there are a lot of stories around this time where you had the nearest male relative was somebody who was willing to take on the child just to have access to their inheritance, and basically blew through their inheritance. And then the child got basically kicked out because they had no more money, or, whatever. There's a lot of stories about that sort of thing where, in the mid-19th century, children over 14 could petition the court for a preferred guardian in some states, increasing their agency. So a 15-year-old in 1860 Pennsylvania might request to live with an older sibling rather than a distant uncle. And the modern laws of the 20th century, gender-neutral laws emerged and child welfare became the focus. Today, courts evaluate the best interest of the child over inheritance concerns, which is really good. And this reflects shifting values towards protecting vulnerable individuals over financial interests. Naturalization witnesses. In the 19th century, witnesses were required to vouch for applicants' residency, moral character, and allegiance. Only white men of good character were eligible to be witnesses until racial restrictions began to relax in the late 1800s. So an Irish immigrant from 1850 New York might bring his employer or pastor as a witness. Women were excluded as both applicants and witnesses at the time. And the reason that they were one of the reasons that they were excluded was because of the status that they had in the community at the time. But another one is if it was a wife, then she was automatically became a citizen under her husband's naturalization. And and that was until, when was that till? I can't remember what year that they stopped doing that. But there was also too that if an American woman married a immigrant, she lost her U.S. citizenship and took up the citizenship of her husband. Think about that one for a minute. Yeah. So some of the 20th century changes were women gained full legal rights to serve as witnesses after gaining suffrage, which in the US was 1920. That's when the woman got the right to vote. Post-1965 immigration reforms eliminated most racial barriers. By 1970, an Asian American citizen could vouch for a friend seeking naturalization. This illustrates the broader trend towards inclusivity and the equal rights in civic participation. And number 5 for tonight was racial and gender barriers in legal processes. The slave era pre-1865, enslaved individuals and free people of color were barred from most legal roles, including witnessing documents or serving as guardians. So a free black man in 1830 Alabama could not legally serve as a witness, even in cases involving other free black individuals. Post-Civil War from 1865 to 1900, freedmen gained right in theory, but faced restrictions like literacy tests and property qualifications in practice. So a black citizen in 1875 might serve as a witness in the northern state, but be disqualified in the South due to the Jim Crow laws. I do not know what the Jim Crow laws are. I didn't have time to go and research that when I came across that. But I'm definitely going to go and look that up, because things like that, I'm sort of like, I need to know. I just need to know. 20th century civil rights movement. By the 1960s, legal reforms, for example, Civil Rights Acts of 1964, Voting Rights Act of 1965 fully dismantled racial barriers in most legal processes. And it highlights the systematic inequality and its eventual correction through the activism and legalization. Let's go make sure I got everything in that one. Oh, and under the citizenship one, the individuals serving as witness in support of a naturalization had to be citizens themselves. So it couldn't be somebody from another thing. And an interesting thing to note on this is even with me right now with passports and that, if I'm applying for my New Zealand passport, like getting it renewed, I have to have somebody witness it who is not related to me. I don't know what happens when I go back to New Zealand, but when I was applying for my passports to be renewed while I've been living here in the States, I had to find somebody who was another New Zealander. They had to be a New Zealander, so they had to be a New Zealand citizen, and not be related to me in any way to sign the documents to say that they know me, that yes, I am a New Zealand citizen, blah, 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 blah. They had to fill out this affidavit thing in order for me to get a New Zealand passport. So I had to find friends who were New Zealand citizens. So I had friends who were New Zealand citizens that I was able to say, hey, can you please be a witness for my passport application? And they're like, yep, sure. So they would fill out the form online and send that in. And 2 weeks later, I got my passport. So some of those things are still in place, but that again, it could be anybody as long as they were not related to me and they were a New Zealand citizen. I will find out more about that when I have to renew my US passport when I'm down in New Zealand. So we'll find out about that one. So with property ownership, early laws tied legal authority to wealth and property, reflecting the economy of the time. The women's exclusion from many roles mirrored broader societal gender inequality. And then racial exclusionary laws reflected systematic discrimination, which diminished with the civil rights movement. And child welfare shifted from guardianship laws highlighting growing recognition of children's rights and needs. So those are just some of the things about, which I thought was kind of interesting. And this article was just like, like a little paragraph. I blew it up a little bit. So, so this, so by looking at the witnesses, because most of them are disinterested party, they couldn't be related to the person. This gives you, when you're looking at the witnesses and things, this gives you other keys of things that you could go and look at, because who are these people that they are getting to witness their documents? Now, in some cases, like in the wills, if they're not named in the will but are a relative, then yes, they can witness it. So maybe that witness was a relative who was not inheriting anything. Maybe it was a friend of the family's. So by finding some of these other names on these on some of these documents, you can go and research and find out who they were, and were they related to that person? Were they somebody that they knew? You can just find out more information. Like, for example, in the my Longland family, I've got a book. I should have picked it. I should have brought it in here. In the Longland family book that I've got there, the Eakins were very much involved with the Longlands, and eventually a couple of the Eakins guys, there was either John or James, but there was definitely a Thomas, married a Longland girl. But before that, there was a lot of interaction with the families. They were very good friends. And in this book, it talked about how the Eakins were put down as the beneficiaries for the wills of the Longlands. Very interesting, because in those days, and this is back in England, and some here in the state, and some of the states as well, is that women could not inherit. So it had to go to a male relative or a male friend. But it had to be to a male. It could not go to a woman. They were excluded from inheriting anything. Now, there was in England, like you have a dowry in England, there was a dowry that was paid to the groom's family. There was a bride's dowry that was paid to the groom's family, and in wills they allowed for a dowry to be given to the woman in the will. That was the only thing. She wasn't allowed to inherit any property or anything else except for this dowry. That was the only thing that she was given, and it had to be administered to her. That dowry was administered by the person who was the beneficiary or the guardian or the overseer of the estate or the trust, and that sort of, well, they weren't called trusts back in those days, but the overseer of whoever, the executor, yeah, that person. They would oversee the property, and they would take on that, and it could be that they could be looking after it until a male child became of age to be able to take over the property. So there's a lot of different laws out there about when people were included, or who had to be, if you're signing this document, you can't witness it because you're mentioned in this document, and there's a lot of different things in there. But I got to find out more about the English law stuff. These just some of the little bits that have come up over time. But this document, this email that came in, I thought, that's very interesting. So I did a little further digging for you to give you some examples and things. But if you want to find out more about the different states, what was going on in your state, what was going on in the state that your ancestors came from, then go down into the description and immediately under the question, which is your question for today, did you know the people named in legal documents like witnesses, guardians, or claimants weren't chosen by chance? What hidden family history could you uncover by understanding their eligibility? And immediately after that, there's a check out the state statutes at, and then there's the website address taking you to Advancing Genealogists, and it takes you to the Laws and Statutes Index for the United States, and you just pick the state. So you can go in there and you can see what was the law at the time when your ancestors lived in that particular state, and what laws are still in place today, what laws and what have changed and what has changed over time. So I haven't had a chance to go in and dig around in there anymore, but the article in the email mentioned that site. So I went and had a look and went, oh, this will have some really cool information. So with that, we are out of here. Go out, have a super fantastic, sparkling evening, and we'll catch you guys back here tomorrow evening at 6 p.m. Pacific. Hei konera.